Hello, everybody. My name is Angasa Ichile McKenzie, and I am here from Southern Marylanders for Racial Equality. Uh, Today, I am pleased to present uh, the forum that we have on students' rights. It's called Pushout in the School to Prison Pipeline. And I am very happy to have Monisha Chirayo from the Public Justice Center to do a really great presentation for you about what rights our students have. Of course, we've seen lots of issues, particularly here in Southern Maryland, around students and families not understanding their rights when it comes to school discipline. And we really want to reimagine what addressing behavior looks like in schools. And she will get into all of these practices. We also have Michaela Wilkes, who is from Schools Not Jails, who it will be here as well. And she will be sharing her thoughts at the end. So we would like those of you who signed up to join us on the Zoom, if you have questions, to please ask them at the end, and we'll, hopefully get some questions as well from the YouTube community. If not, I appreciate all of you for coming, and I will let Monisha take it away.
Great. Thanks so much, Angasa, and everyone for being here. And as you said, I'm Monisha Chirayo. I'm with the Public Justice Center, which is a legal services and advocacy group. We're based in Baltimore, but we work throughout the state. And our education stability project is focused on protecting and expanding the rights of students, and really ensuring that we keep them in school and shift away from practices that push them out. So I think what we're going to do today is I will go through a presentation on the issue of push-out and really the rights and protections students have. I know many of you are parents, are educators, are advocates, or service providers that work with young people. So this information hopefully will be useful to all those young people you touch in schools throughout our state. And then we'll have Michaela speak from her perspective, really on the ground in terms of her experiences with push-out, and then we'll open it up for some questions, as Angasa was saying. So I'll go ahead and share my screen. Angasa, I'm assuming everyone can see that?
Let me see. Yes, I'm trying to make sure that we can get, I can't hear the audio on YouTube. That's, I'm a little bit concerned.
Okay, you want me to pause for just a second while
yes, thanks.
I'm gonna the YouTube part. Okay.
I'm gonna see if we're having some sort of technical situation here. No, it looks like we should be. If anybody's watching on YouTube, let us know. Let me see. Let me click it again. Yeah, now we can hear. If anybody's watching on YouTube. Okay, you're good.
Great. All right, let's get right into it. Okay. So when we use this term push out, what are we talking about? Well, when I use that term, and when I use it throughout this presentation, I'll be referring specifically to decisions by schools and actions that happen within schools that exclude students because of their behaviors. So suspension, expulsion, forcing kids to transfer out of their regular school to alternative schools, as well as school-based arrest. And of course, we know that there's other sort of policies and practices that can push kids out if they're just not engaging kids or meeting their needs. But for purposes of this presentation, we're referring very specifically to actions that in the moment really directly pull students out of school, and as we'll see, onto a pipeline towards prison. So to begin, let's just speak, very concretely about why the traditional approach to student behavior challenges which is to pull students out of school in these various ways, simply does not work. That's how we've been doing it for a long time. And so we actually have quite a bit of data and research demonstrating its failures. We see that suspending students doesn't reduce recidivism, doesn't prevent future suspensions, because it doesn't address the underlying causes of behavior. And this is intuitive, right? We pull a kid out of school for fighting, we leave them home. They're not learning, we're not teaching them how to resolve the conflict that led to that fight. We're not teaching them to engage more constructively with one another. We're simply leaving them on their own. So we're not sort of addressing the problem at its root. We've also seen that the use of practices like suspension, expulsion, school-based arrest, despite popular perception to the contrary, does not make schools safer. Again, because we're not teaching kids how to improve their behaviors. We're not providing students with support to engage in safer, more constructive ways with their peers and with the school community. So we found that there's not, use of suspension, expulsion doesn't improve overall school climate, doesn't sort of reduce those types of instances in the future. And I'll focus in particular with respect to this question on the issue of school police. I think in many people's minds, there's the idea that school policing and the school-based arrests that come along with school policing are a necessary component to school safety. But with the expansion of police in our schools statewide and nationwide over the last 40 years, we have seen that that link actually just does not exist. No national study has found that the presence of police decreases school shootings or any kind of school-based violence. In fact, there was a study that came out just a couple months ago that found that school police presence was linked to an increase in fatalities resulting from school shootings, perhaps because kids are coming in, with larger capacity weapons. There's other theories as well. But bottom line is there was actually an increase in fatalities when shootings did occur if a police officer was present in the building, right? And then there's the questions around sort of aside from actual school safety, is there an increase in perceptions or feelings of school safety when officers are present?
Did you guys leave the Dollar Tree?
Yeah, we left for lunch.
No, because your dad was talking about the shredded cheese. I don't know if you
You know what? I think if folks on the Zoom can make sure to mute.
You didn't put it in the list, all right?
Hello?
Was it on the list?
I remember you mentioning it. Remember when he was saying he wanted to make those?
I'm going to pause for a second.
I'm sorry. I'm muting everybody. I'm sorry.
Everyone that's not.
Yep. Done.
Okay. So no increase in actual safety, no decrease in instances of violence associated with school police presence. And in terms of perceptions or feelings of safety, sure, some parents, some students certainly do report feeling safer when officers are around the school, but it depends on who you ask. It certainly depends on race. We find that Black students report that police presence in schools make them feel less safe. Recent national report came out showing that 40% of students overall felt less safe with an officer in their school building. Okay. Second sort of criticism of push-out as a practice. We know when we look at the numbers that it is used, suspension, expulsion, school-based arrest for minor and subjectively determined behaviors, right? Again, there's sometimes a perception that we're only kicking kids out of school in the most egregious, extreme circumstances. But in fact, we see that over a third of suspensions and expulsions in Maryland schools in the most recent year for which we have data were for disrespect or disruption, right? Which very much are offenses that are in the eye of the beholder, right? A kid talking back or engaging in horseplay in the hallway. Kids get kicked out of school for these types of behaviors, even though we know they are part and parcel of being a kid, very much an opportunity to teach rather than to exclude without teaching, right? And same goes even for school-based arrests. The vast majority are for run-of-the-mill fights, disruption and disrespect, and property offenses. I'm talking about destruction of property or theft, oftentimes talking about very low dollar amounts. Charles County example is a student who colored on another student's jacket and was arrested in school for malicious destruction of property. So that gives you a flavor of the kinds of reasons kids are getting kicked out of school and even arrested for their school behaviors. And again, to zoom in on the particular issue of school policing here, here's how it breaks down, right? We see that the most common basis for school arrest is fighting without weapons, right? The run-of-the-mill schoolyard shoving match. The really sort of serious, more serious offenses, perhaps, weapons or guns are very much in the minority of what's going on and what's contributing to our school-based arrest numbers. Around 3,100 arrests in schools per year in Maryland. And then we also know that Pushout harms kids, right? It doesn't work. It doesn't solve the problem. It's being used for minor behaviors, and it hurts both the individual kids impacted and the overall school community. We know, again, from years of research that suspensions, school-based arrests, cause children to disengage from school, kind of puts them on a downward spiral towards poor academic performance, grade repetition, and eventual dropout, with both long-term and short-term increased contact with the juvenile and criminal legal systems. One study found that a single suspension increased by about threefold the likelihood that a young person would end up having juvenile system contact. And these harms are not suffered in the same ways by all students. Students of color and students with disabilities disproportionately bear the burden of school pushout. So we see here Maryland data on suspension and school-based arrest by race. In this chart to the right, we see the overall student population. Black students are about a third of our state student population, but they're getting 59% of our suspensions. They're getting 56% of our school-based arrests, very disproportionate to their overall representation within the student body. And we know that that's not because there are differences in behavior across race. What we know is that even when students behave in the same ways, Black students are more likely to get arrested in school or suspended as compared to their white peers. We see similar types of disproportionality with students with disabilities, students who have IEPs or special education plans. Again, to the right, we see that in terms of representation within the student population, students with IEPs are about 12%, but they get 25% of our school suspensions and 23% of our school-based arrests. And what we see in the research, as well as sort of in my practice representing students, is that oftentimes this is because students with disabilities are being suspended, being arrested for behaviors that arise out of their disabilities. So a student with ADHD, classic symptom of their condition is impulsivity, right? And then, they end up responding in an impulsive way to a provocation, sort of lashing out or, wandering off when they should be staying in a classroom, and they end up getting in trouble for that, getting kicked out of school. And in a way, if you think about that, that's really sort of discrimination on the basis of disability, right? You are kicking a kid out of school, depriving them of their education because they have a disability that causes them to behave in certain ways. And we see that these types of disproportionality exist across the state in every single district. So just want to be really clear that it's not like we see race-based disproportionality only in districts that are overwhelmingly white or only in districts that are overwhelmingly Black. No matter what the demographic makeup is of a district, we see disproportionate levels of suspension affecting Black students. Same goes for students with disability. The disproportionality exists in every district in Maryland. And so, you know, at the end of the day, we see that Pushout is ineffective, and it's overused, and it harms children in the school community, which is why we, you know, as parents, advocates, want to be moving school districts away from that approach and towards strategies that actually work. And the good news is that there are plenty. And I'll just quickly summarize a few here. Restorative approaches or restorative justice is really about a holistic transformation of a relationship building in sort of a school setting. So we spend time proactively fostering relationships between students and between students and staff, which helps to prevent conflict. And when conflict does occur, gives us sort of a relationship to repair. It makes it easier to get back on track because people are actually invested in their connections with one another. We see PBIS, which many of you have heard of. It's really sort of what it sounds like. It's incentive structures to support positive behavior. We've got trauma-informed teaching, which is really founded on a recognition that some kids act out and hurt others because they're hurting themselves. You know, they've experienced a trauma like homelessness or loss of a parent, and they may respond with sort of a flight or flight response when triggered, which might look like aggression. And so the way to deal with that is to be able to recognize the signs of trauma, respond to that trauma, including by providing mental health services, rather than simply pushing kids out of school. And I'll just skip to the last one and highlight special education identification and planning. And we talked about how some kids act out because they have a disability that causes them to behave in those ways. And special education is all about helping to provide students with services that address their disabilities, and that includes behavioral disabilities. Having strong systems to identify students with disabilities and then serve them through their IEPs or 504 plans is yet another way to support positive behavior without pushing kids out. So, so having said all that, let's sort of dive into the rights that students have when they are confronting different forms of pushout. Right? We know that we don't want our kids to be pushed out of school, but let's make it really concrete. When it's our own child or a friend's child or you know, a student of ours who is confronting a removal from school because of behavior, what can we do for that child? What can that child do for themselves? And I'll start with the discipline context. So when we're talking about an effort to suspend or expel a child, will turn later to school-based arrest. So the good news is Maryland actually has some fairly strong law on the books when it comes to protecting students who are facing disciplinary removals, suspensions, and expulsions. And that's particularly true for longer term removals, the extended suspensions, which are 11 to 44 school days, or the expulsions, which are defined in the law as 45 school days or more. So there's sort of graduated levels of protection based on the length of the removal at play. So I put this up just so you kind of see what we're talking about and how the law defines a short-term suspension as 1 to 3 school days, long-term 4 to 10 school days, extended 11 to 44, and expulsion as 45 or more school days out of school. So short-term and long-term suspensions have sort of the lowest level of protection, but nonetheless, there are protections there. So first piece, the principal does have discretion to suspend a student in the short-term or long-term range, so anywhere up to 10 school days. It's the principal's decision. But they are not sort of unfettered in their discretion. They have to sort of follow certain standards. So for example, they cannot suspend for attendance related suspensions. A student cannot be suspended for skipping class, for skipping school, for being tardy. You cannot do a hall sweep where you round up everyone that's in the hallway after the bell rings and give them a 3-day, which we see all the time. And it makes perfect intuitive sense, right? Why are we kicking kids out of school? Because they were skipping school. And yet that continues to happen. So it's an important thing to keep in mind. No length of suspension is appropriate for an attendance related offense. In terms of sort of the basis otherwise, the principal's got to adhere to their school district code of conduct. And these certainly vary from district to district. But what I would say is that, when I get a case, first thing I do is look at the code of conduct in that particular district. And those codes of conduct are supposed to lay out graduated responses and different types of responses for different offenses, depending on sort of severity and safety concerns. So the principals are bound to those, and they're supposed to follow them. And they also have to follow a particular process. They have to hold a conference with the student or parent, and they must give the student notice of the charges, an explanation of the basis of those charges, and an opportunity, if they want to present their side of the story. Now, when a student is on suspension, on a short-term or long-term suspension, they also, the school has to have mechanisms in place to make sure that they don't suffer academically. So they have to have the opportunity to complete work they've missed without penalty. They must actually designate a staff member whose responsibility it is to ensure that the student gets, the work they need and doesn't fall behind, and so that the student has a parent, or rather, a student or parent has someone they can call if things are not going as they should. That's typically, as a practical matter, sort of how things go when you're talking about like a 1 to 3 day suspension. Typically, they're just going to have the student make up the work when they're back, or give them some work packets while they're out. For a longer term suspension, they should be providing the work on a more regular basis rather than letting it accrue and having the student just make it up when they're back. And it actually has to be corrected by the teacher. And again, there should be a liaison to facilitate that contact so that the student gets the work and completes the work and gets the feedback that they need. Now, with extended suspensions and expulsions, there's several additional layers of protection. So the first thing that's important to understand is the principal actually does not have discretion to suspend a student for more than 10 school days, because right now we're talking about the 11 plus school day range. When you get into that range, it's not in the principal's hands. All they can do is suspend for up to 10 school days, and then they've got to essentially make a recommendation to the school district's designee for suspensions and expulsions that they want this child out longer, or they think the child should be out longer. And then it's the determination of that district level person whether or not it's appropriate to remove the student for longer, for 11 school days or more. And that superintendent's designee can authorize an extended suspension or expulsion only if certain fairly high legal standards are met. So if we're talking about an extended suspension, 11 to 44 school days out, there's only 2 scenarios where that can happen. That designee has to look at the facts, look at what happened, look at the student's particular circumstances, and what alternative approaches could be put in place, and determine whether these standards are met. And those two narrow standards are that the student's return to school would pose an imminent threat of serious harm to other students and staff, or that the student has engaged in chronic and extreme disruption of the educational process that's created a substantial barrier to learning for other students across the day, and other available appropriate behavioral and disciplinary interventions have been exhausted. So, you can go through and see all the limiting language that's in there, right? Either having the student in the building will essentially mean that other students or staff are immediately in danger for their safety, or it's a really extreme situation with disruption, and they've tried everything else besides an extended removal. And then if you're trying to expel a child, so 45 school days or more, the only circumstance you can do that is if that first standard is met. So the student's return to school would pose an imminent threat of serious harm to others. So the idea here is that we really can only use these particularly long removals in the most dire circumstances, when we've exhausted all our other options, or where there's an immediate safety threat. So the process here is that the principal would make the recommendation for the extended suspension or expulsion. The superintendent's designee would investigate the matter, look at the student's records, talk to staff or other students who were involved or witnessed the incident. They would then have a conference with the student and their parent within 10 school days of the principal's initial removal. And at that conference, the student and parent couldn't be represented. They could share their side of the story, share why they believe that the standards have not been met. And then the designee would make a determination. That determination also has to be made within the 10 school days, right? So it all has to happen very quickly, because we don't want to keep kids out for longer and have them continue to miss school while we're figuring out, whether various legal standards have been met. If the evidence doesn't rise to that standard, the student gets to go back to school. And let me just pause and say one thing about the imminent threat of serious harm standard. It really is a forward-looking standard. So I think a lot of people and a lot of designees that I see tend to look backwards. They think, okay, well, there was a fight last week. The student was involved in a fight. It was a bad fight last week. Obviously, if we bring them back to school, there's an imminent threat of serious harm. Kids are going to get hurt. Kids already got hurt in that fight. But the reality of the legal standard is it's a forward-looking standard. And the fact that someone got into a fight last week doesn't necessarily mean they'll get into a fight next week, right? Especially if you as a school are doing your job and trying to provide other supports and so forth. So the analysis really has to look at not just what happened, but what's likely to happen if the student comes back. Okay, so after this conference, let's say the designee determines that one of these legal standards is met, and they go ahead and issue the extended suspension or the expulsion. The student and parent then have a right of appeal. They can appeal to the school board of the district within 10 days, and then the school board's got to decide that appeal within 45 days. They decide that appeal usually through a formal hearing process where there's witnesses, where there's opportunity for testimony and questioning. And when you're in that scenario, the district actually has to sort of turn over their evidence, turn over their witness list before the hearing, so that the student can adequately prepare and they can bring their own evidence and their own witnesses and all of that as well. The other piece is is what services does the student get while they're out, right? We talked about how in the short-term and long-term setting, the law wants the district, wants the school to take steps to ensure that the student doesn't fall behind while they're out of school. And that's also true, even more true, when we're talking about removals of 11 school days or more, right? Extended suspensions or expulsions. In this scenario, students really must be placed in alternative education programs that allow them to earn credits, that allow them to stay on track with their curriculum, and allow them to reintegrate once they're done with their extended suspension or expulsion. Now, the exception would be if the student or parent actively decides they don't want to be in an alternative school. If that's the case, the school, the district isn't off the hook. They've got to provide the classwork on a day-to-day basis, which the student would then have the opportunity to submit and get feedback, get a grade on a weekly basis, get support throughout that process, again, with the liaison to their school. But typically the default is an alternative school, and it really has to provide the same quality of education in general as they would get in their regular school. Let me actually just pause for a moment. I know I've been talking quite a bit, but since we're making decent time, let me quickly see if there's any questions before we kind of go to some red flags. Okay, let's move right along. So, we've been talking about the rights that students have when they're suspended or expelled. Okay, no worries.
Really quick, sorry, I didn't find my unmute button.
No worries, go ahead.
I was interested in the statistics for the disabilities.
Sure. What was your question about it?
I just wanted to see it again.
Oh,
If I didn't know if the slides were going to be available or.
I can share the slide. So I can give you the statistic, and then I can share the slide afterwards. I don't want to lose my place too much in the PowerPoint.
Go ahead. Yeah.
Just as a refresher, students with IEPs are about 12% of our overall student population in Maryland, but they get 25% of suspensions and they get 23% of school-based arrests. Okay, so
can I ask you a question?
Yeah, go ahead.
I'm a student at Bowie State University. I'm criminal justice,
Mhm.
and we're doing some things on restorative justice, and so that's why I'm participating today. So
Sure.
I'm going to make sure this is my last semester, but we're kind of following up, doing some research for one of the professors there. So I'm going to make sure that he gets the contact information so that he can follow up, because they're doing a lot of grant writing and a lot of stuff on restorative justice, and this might be helpful.
Sure. Yeah, I'm happy to connect.
Okay, thank you.
Yeah. Yeah, sounds good. I'll make sure to send you the slides, and I will put my email in the chat at the end of the presentation.
Thank you.
So so we've been talking about what students' rights are when they're suspended or expelled. The tricky thing is that at least with suspensions, school staff don't necessarily always use that label. What we sometimes hear is, a parent calls us and said, well, the school just called me to pick up my child and take them home because they were acting out, they were having a hard day. Or with an older child, they might even tell the child themselves, look, you have just been a mess all day. Why don't you go home a little bit early, come back on Monday when you're prepared to sort of act the way you need to be. That is a suspension, even though it's often not called a suspension, even if it's not recorded in school records as a suspension. But it is a suspension. All the rights we've been talking about apply. Same goes for administrative transfers to alternative schools. In some districts, a practice that we see is that a principal or even a superintendent's designee will say, okay, look, you got in this fight, you got in trouble, but I'm not going to suspend you. I'm going to do you a favor. I'm going to just transfer you to this alternative school, right? And then you won't have an expulsion on your record. You won't have a suspension on your record. Here's the thing. That's still a suspension or expulsion. And you want it to be treated that way because again, these protections that, for example, the high standard for an extended suspension or expulsion has to apply. And they can't sort of skip that process, skip those standards by calling it something else. And then, calls to the outside police certainly can be a way to sort of circumvent the whole process, or school police as well. I'm going to sort of briefly touch on another type of behavior-based removal from school that's a bit different because it relates to behavior that happened outside the school building. And that's the issue of removals for reportable offenses. Now, there's a law that essentially says if you are arrested for any number of a long list of offenses out of school, including things like, theft over a certain amount, or homicide, or other types of very serious offenses, but even things like certain drug offenses or assault too, which can be essentially any fight. This occurs in the community. You are arrested for one of these offenses. The police department is going to report your arrest to your school system. And then essentially your principal has a good amount of discretion to decide how they're going to respond. What they're supposed to do is to develop a plan that addresses appropriate educational programming and related services for the student and maintains a safe and secure school environment for all students and school personnel. That's theoretically the standard, right? They respond. Maybe they, because you were arrested out of school for some kind of incident, they determine that they want to change your schedule, or they want to engage you in counseling, or that they want to remove you, right? And unfortunately, the way the law is written currently, they've got quite a bit of discretion to do that. But an important thing to keep in mind is it's not unlimited discretion. What we see happen all the time is that the principal automatically removes the student, kicks them out of school, puts them in online learning or alternative school because of the fact of the arrest alone. And the State Board of Education has made clear that that's not legal. They cannot do that. There's got to be some basis for believing that that change is necessary to protect the school environment. Okay. So all the protections I talked about so far, all the rights I talked about so far, apply to all students in Maryland public schools, whatever grade they're in, students with disabilities, students without disabilities. But now I want to shift and talk about certain populations that are entitled to additional protections on top of what I've already been through. Okay, first, our littlest students, our students in grades pre-K through second grade. Under a law passed in 2017, school districts as a general matter, schools as a general matter, should not be suspending these students. It's only under very narrow circumstances that they can do so. So sort of starting point is, if you're in pre-K, first grade, second grade, you act out, you shouldn't be kicked out of school. Again, it's intuitive. These are little kids. Part of the reason we send them to school is to learn how to behave. You know, for those of us who have little kids know that there's no way they're not going to act out sometimes. And kicking them out of school is essentially derailing their education before it even starts. So as a general matter, it shouldn't happen. There is an exception. One very narrow exception is if expulsion is required by federal law. The only time expulsion is required by federal law is if a student brings a gun to school. So even a little kid, kindergartner, if they bring a gun to school, the law says they can be expelled. That's a very narrow exception. We know that's not generally what's happening. The other exception catches kids up a little bit more. A student may be suspended for up to 5 school days if the administration, the principal, in consultation with a school psychologist or other mental health professional, determines that there's an imminent threat of serious harm to other students or staff that can't be reduced through interventions and support. So it's that same high standard that we talked about in the context of expulsion or extended suspension, but it's actually even higher because the principal can't make that determination alone. They've got to consult with a mental health professional who's engaging with the kid and figuring out if there really would be an imminent threat going forward. You know, the removal is capped at 5 days total. So even if you find that there's an imminent threat of serious harm, there's nothing else you can do about it. Your only choice is to remove the kid. You can still only remove them for a maximum of 5 days. I will say we do see violations of this law around the state. We do see workarounds. One in Charles County. Charles County established the Fresh Start Academy a couple of years ago, just after this law was enacted, in fact, where they were taking the position that they would remove students in grades K through 2 if they were acting out in serious ways, but they would not call it a suspension. They'd be removing them to another school, an alternative school called the Fresh Start Academy. There was a determination by the Attorney General's office that if that is a mandated, involuntary removal where you're forcing the student out, regardless of whether they want to leave, regardless of whether the parent wants them to stay, that does in fact count as a suspension, and would be subject to this pre-K to 2 suspension ban, such that kids could not be removed to Fresh Start Academy for more than 5 days, even for significant behaviors. The Charles County Public Schools has sort of reformed or revised their policy around FSA to say that it's admissions on a voluntary basis only. What I would say to our Charles County listeners, if you do have a child or you know of a child in CCPS who's being considered for Fresh Start Academy, their parents need to understand that they cannot be forced to go to Fresh Start Academy. They can only be put there if that's what the parent wants for them. And in the meantime, what I often say with respect to students in Charles County or anywhere, young children who are really acting out in significant ways, oftentimes that should be a trigger for a conversation, at least, about disability. Is that the root cause here? And is now the time to catch it early and address it without excluding the student? So that's our youngest learners. And then the other special population that gets additional protections are students with disabilities. Now, when we're talking about short and long-term suspensions, anything up to 10 school days, they don't have any additional rights beyond what all students get. So they're sort of treated the same as students without disabilities. However, if a school wants to suspend them for more than 10 school days, they've got to go through an additional process. They've got to hold a manifestation meeting. And what that is a meeting to determine with the IEP team and with the parent if the behavior at issue was either caused by or had a direct and substantial relationship to the student's disability, or was the result of the school's failure to implement the student's IEP, right? So, and if the answer to either of those is yes, then as a general matter, in the vast majority of cases, then the student has a legal right to return to their school. Narrow exception, if the behavior involved drugs, weapons, or serious bodily injury, and we're talking about sort of, disfigurement, death of another person, really extreme serious bodily injury, then there is an exception that says, well, the student can be put in an interim alternative placement. But in general, if the behavior was a manifestation of their disability or the failure to implement the IEP, kid goes back to school. If it wasn't a manifestation, if it was not related to their disability, then they are sort of back in the bucket of being treated exactly the same as general ed students, and they can be suspended for more than 10 school days. But while they're out, they should get, in addition to the comparable education services we talked about before, their IEP services and support. So in that alternative school, they should be getting the equivalent of what they would get under their IEP in a regular school setting. So that's sort of the rights that students have when it comes to disciplinary removals, suspensions, expulsions, forced transfers. And I'm going to touch just briefly on the rights that students have when it comes to school policing. I know that Southern Marylanders for Racial Equality actually hosted a whole separate session on the juvenile justice system, or the juvenile legal system, and the rights of students in the context of arrest and in police interactions generally. So I'm not going to sort of repeat all of that. Whether you're a young person being arrested in school or out of school, many of your rights are the same. And that's the subject of, sort of the separate presentation that already happened, and sort of all the protections in the criminal legal system generally. But I'll offer just a few sort of concrete pieces of information that are particularly relevant when we're talking about school policing and school-based arrest. So one, again, and this will be familiar to folks, students, like anyone else, have the right to remain silent when it comes to interrogation by a police officer, even if it's a police officer in their school. They can say, if they're being questioned by a police officer in the school, including an SRO, that they'd like to exercise their right to remain silent. They can also say that they don't want to talk to the principal in front of the SRO or a school police officer, right? Sometimes you have both of them in a room coming in after an incident trying to talk to the student, or maybe it's just the principal that's engaging directly, but the SRO is standing right there. In that scenario, where the student feels like the SRO will use information that the student has heard, or rather they are hearing from the student against them, which is always a possibility, the student can again say they don't want to talk with the officer there. Arrest, with police interactions, police interrogation, police arrest, a student can say, I don't want to talk, I want a lawyer. And they can also refuse to consent to a search, which is not to say, by the way, that the search may not still happen, or the questioning may not still happen. But if you assert your rights, then you may be able to use that to protect yourself down the road if there is ultimately a juvenile or criminal case of some sort. And of course, not, yeah. Right. Yeah, absolutely. I know. And this is why we try to do these presentations, to get the word out, because people just don't know. And there's a huge power imbalance, of course, when we're talking about a student in a school and an officer or the principal. And just to be clear, I mean, there are circumstances where it's legal to do a search without consent. But then there's additional hurdles that have to be met, right? So I think it's often worthwhile for the student to assert their right that they're not consenting, so they don't use that as the reason, and they have to, at a minimum, come up with some other legal justification for the search in the absence of consent. So, having gone through the rights and the limitations and the use of exclusionary discipline and school-based arrest, I also want to offer folks some of the alternatives to advocate for, both at the individual level with a particular kid, and at the more systemic level in terms of the policies and the practices that your district pursues. So one, sort of restorative justice, community conferencing. We talked about how kicking a kid out of school after a fight doesn't teach the kid to engage in more constructive ways to solve their problems peacefully, solve their conflicts peacefully. But what does is community conferencing or mediation, where we actually are sitting students down, and getting them to understand and confront the harm they've caused and take responsibility for it, right? So particularly if the behavior that's resulting in the recommendation for suspension or expulsion is a conflict with another student or with a staff member, we often advocate that we push for trying community conferencing instead, or mediation instead, and it could be done sort of with school staff. It could be done with outside experts. In Southern Maryland, for example, there's a mediation, a community conferencing center of Southern Maryland that plays this role exactly. And there's sort of analogs in different parts of the state. So, I mean, it's not necessarily a process that works all the time. All parties really do have to consent for the process to work, but it's definitely something to advocate for, and to advocate for schools to pursue before they kick a kid out. Oftentimes I hear schools saying, "Oh, we're doing restorative justice. We're going to kick the kid out. When they come back 2 weeks later, we'll do the conference." Which, the conference at that point may still have some merit, may still have some value in terms of repairing harm and holding the student accountable. But really the most value would be at the beginning, and using that as an opportunity to actually sort of hold the student accountable, teach them to do better without kicking them out of school and forcing them to miss out on their education. An FBA, a functional behavior assessment, is another very specific process that you can advocate for. Schools, I think, most often do these and think about these in the context of students with disabilities. They actually can be done for any kind of student. And what this is essentially a study, right? A student engages in certain kinds of problem behaviors, but you take the time to really observe and figure out, well, what specifically are the 1 or 2 or 3 behaviors? When do they occur? What triggers them? Why are they engaging in these behaviors? What is the function of the behavior? Are they trying to get attention? Are they trying to get some kind of sensory feedback? Is it that they are anxious and stressed out by a scenario and reacting to that? So you figure out, the triggers, the purposes of the behavior, and you recommend replacement behaviors and responses that the adults in the school building can pursue to get the student back on track. So, for example, if our FBA tells us, okay, the student acts out really because they want attention, they want the teacher's attention. We might then say, well, let's figure out a way to give them attention in a way that rewards positive behavior rather than as a response to negative behavior, right? And those types of teacher or staff responses are what's laid out in this next bullet here, a BIP, a behavior intervention plan. So that's literally speaking to the staff in the building and saying, here are the concrete ways in which we're going to engage with the student to support their positive behavior. It can include things like speaking in a low tone of voice, giving them wait time before you follow up and tell them to comply with the rule again. Having certain types of incentives or having a cool down space. So these are very concrete strategies that we can implement with any students. For students with disabilities, sometimes what we need is an update to their IEP or 504 plan. Maybe they need additional mental health services, for example, as part of their IEP, or additional accommodations. And then sort of more broadly, outside the context of an individual student, we should be advocating for these types of practices across the board for a real district level investment in restorative justice, investment in student mental health services, investment in wraparound supports. We know that across the board, school districts in Maryland are understaffed in terms of their school psychologists, their counselors, their social workers, their nurses. We know that most school districts don't have any real restorative justice program to speak of. Most schools don't have community school coordinators to connect kids with food and housing and all the other services they need in their communities in order to be able to behave and be successful in school. So long term and broader scale, we want to be advocating for those transformations at the district level, so that we can truly move away from these ineffective practices around push-out and towards strategies that work. And truly, they've been shown to work and to measurably improve behavior and reduce conflict and improve school safety. So let me stop there and see what questions folks have, and then I'll make sure to leave you with one quick resource and turn it over to Michaela.
Hello. Hello, thank you for all that information. I was wondering, is it possible when you're talking about, I'm in Western Maryland, Allegheny County, putting in the IEP that a parent be present if the police was to come in and question? Could that be placed in the IEP?
That is an interesting point.
Like if the child has a certain response to authority figures to please them, and the child wants to please authority figures, so they may not tell the truth in order to please the authority figure, that the parent needs to be present during any questioning. I'm a former law enforcement officer turned educator, so
interesting.
I'm familiar. I'm trying to get familiar on both sides.
So the tricky thing with school police is, in every single school district except Baltimore City, so in Allegheny and all the districts out west and every other district, school police are actually not employees of the school system. Right. They are, and you may know this already, but they are employees of the local sheriff's department or police department, city or county level, and they're brought in by way of an MOU. And so they report directly to police chiefs and not to principals and superintendents. And I would expect that as a result, school staff often say, well, we can't tell the officers exactly what to do. And I would expect that as a result, the IEP team would be quite reluctant to ever agree to any real limitations on school policing or how an officer interacts with a student in the context of an IEP. So my sort of preliminary reaction is, while I really like that idea, I think it's hard to push for, but I would love to actually give it some more thought. And I'll circle back if I want to look into it a little bit more. And I think it's a really interesting idea. And if I can think of a good way to make that happen or to successfully advocate for that, I will definitely circle back with you and we'll figure out a way to connect so I can share that. I don't. I just want to. Whoops. Just want to make sure you all see this. If you all want to screenshot that, or I will actually also put it in the chat. I'll put the info in the chat. This is the Maryland Suspension Representation Project. My organization, the Public Justice Center, partners with other organizations in Maryland, the Disability Rights Maryland. There's a law clinic at the University of Maryland School of Law and the Office of the Public Defender to represent students statewide for free if they're facing suspension, expulsion, school-based arrest. We will represent students in districts, any public school in the state in these types of cases. So feel free to call or have students or parents call if they're getting suspended or facing any of these types of removals. I should clarify, this even we'd even take cases where there's a removal from online learning. Because those can be disciplinary removals as well. And you can also check out our website. There's an opportunity for folks to do sort of an online referral there as well. So I'll put that info in the chat. And again, I'll be sending around this PowerPoint.
Yes, hi. That was a great presentation, Monisha. Yeah, so I pretty much will just validate every single thing that Monisha has said, every single thing that she has presented, because I've lived that. I'm both someone who has been directly impacted by being thrown directly into the school to prison pipeline. And I'm also a parent of 2 children who attend Charles County Public Schools. And so to speak about, the reasons why we're in a predicament where students have to even know their specific rights, even in a school setting, right? Because we have a system that is based on incarceration, and it's based on more punitive approaches than restorative approaches, even down to dealing with our youth. And so unfortunately, we are in a situation where our children aren't even safe in schools as it pertains to being thrown into the criminal justice system. In my situation, I was incarcerated in a juvenile detention facility. There is a program called the CHINS program. Actually, I believe the acronym is for Child in Need of Supervision. And I was at the time dealing with a lot of grief. My aunt had passed, and so on September 11th, she worked at the Pentagon. And so I was essentially dealing with a lot of depression. In retrospect, I wasn't diagnosed at the time, but it was actually my school guidance counselor who noticed that I was missing a lot of school. And, I used to talk to her and I would tell her, I don't feel right. Like I just can't, bring myself to come to school. I can't bring myself to be around anyone. And she warned me, and her warning was, if you continue to miss school, they will put you on a program and you will go to detention and they will put you in a group home. And they did every single one of those things. Instead of offering me help or, offering me some kind of program to deal with the tools of how to handle my depression, I was instead told that I would be incarcerated. And so for every one day of school I would miss, even if I was late to a class, even if I skipped one class, I faced up to 10 days in juvenile detention, which happened very frequently. And this process went on for probably about the better half of about 2 or 3 years, until I was removed from my home, put into a group home, and then threatened with foster care. And to touch on what Monisha said about, school principals having discretion and being able to come into certain decisions, my high school principal actually attended several of my court cases just from me being late to school, or just like maybe like a status hearing, because they call it a program, but what it is essentially probation. So I had a probation officer, and my school principal would come to like pretty much all of my court dates when my probation officer was trying to put me into a foster care system, because at this point, after the better part of the 3 years, they gave me a psychiatric evaluation after incarcerating me on and off, for skipping class or skipping school. They diagnosed me with depression after court ordering that I get a psychiatric evaluation. And my school principal actually came to, I guess, make her statement to the judge that she wanted to recommend that I go to a foster care, that I go into a foster care system. And so these are just a couple of examples of like what actually goes on in schools, and kind of, and kind of shaping the way to reimagine how we think about school safety, to reimagine, having school resource officers, because I was picked up by a school resource officer for smoking a cigarette off of school property. But the school resource officer just so happened to be riding around the neighborhood around the school, found me, picked me up, and detained me. And I did not know my rights. I did not know to say that I did not want to speak to the police officer. I didn't know any of that. And it caused me a probation violation. And I ended up in detention for that as well. So, I hope that people that are on this call and also people that are watching YouTube, will understand that we are in this situation because of the way that the system works. When we send our kids to school, we don't expect them to be arrested. We don't expect them to be tackled, handcuffed. We don't expect them to be questioned. We don't expect them to be criminalized. We don't expect them to be policed. But that's unfortunately what's happening in our system to our kids. And so this is why it's really important that, children do know their rights until we actually get to a point where we have a school system and an entire political system that actually keeps marginalized communities safe, including people of color and people with disabilities, especially our children who are our most vulnerable. And so we should be practicing restorative approaches, for instance, like peer-to-peer, peer mediation, and allowing children to talk out their issues when they get into a mutual fist fight instead of arresting them, creating safe spaces in schools so that children can actually have someone to speak to about their problems, and also employing more guidance counselors. And schools have guidance counselors, but a lot of school guidance counselors focus primarily on administrative work. So just making sure you're on track to graduate, but not really necessarily there in a mental health capacity as they could be to actually help these kids out. So yeah, just want to completely validate every single thing that Monisha has already said for the duration of this call. And just hope that we can get to a place one day where calls like this are not needed. And we actually have a system that works for everyone, and a system that actually wants to keep our kids safe and protect them by actually giving them the resources that they need to thrive.